Hello, I'm Madison Hassey. Currently, I am a postgraduate intern at the National Office, and I work with the Division I Bylaw team that oversees Bylaws 12, 15, and 16, and I also work with the Division II team. In this presentation, I am going to give an overview of the information in Division I Bylaw 12. Bylaw 12 is titled Amateurism and Athletics Eligibility. With regard to amateurism, this bylaw outlines the governing principles for individuals outside of the institution and their involvement with student athletes, for example, professional sports organizations or boosters. Athletics eligibility refers to eligibility outside of the academic context, specifically seasons of competition and the 5-year rule. Bylaw 1201 outlines general principles pertaining to amateurism, and Bylaw 1202 provides relevant definitions for terms and phrases used throughout this legislation. Included are the definitions for an agent, actual necessary expenses, organized competition, and professional athletics team. Bylaw 12.1 outlines general regulations to retain amateur status, including prohibited forms of pay and exceptions to the amateurism rule. All prospective student athletes must receive an amateurism certification from the NCAA Eligibility Center to be able to be eligible for practice or competition at any Division I member school, and it is the responsibility of the institution to determine the validity of the information used to certify a prospective student athlete. An individual loses amateur status and thus shall not be eligible for intercollegiate competition in a particular sport if the individual uses athletic skill for pay in that sport, accepts promise of pay, signs a contract to play professional athletics, receives, directly or indirectly, a salary, reimbursement of expenses, or other financial assistance from a professional sports organization, competes on a professional team, after full-time enrollment, enters a professional draft, or enters into an agreement with an agent. While it is impermissible for a student athlete to receive pay, such as a salary, gratuity or compensation, division, or split of surplus, it is important to note there are expenses, awards, and benefits that are permissible for student athletes to receive. For example, in individual and team sports, they may receive actual and necessary expenses for competition and practice from an outside sponsor, provided the outside sponsor is not an agent, a booster, or, after full-time enrollment, a professional sports organization. Bylaw 12.2 governs the involvement of individuals and student athletes' involvement with professional teams prior to and following initial full-time collegiate enrollment. After full-time enrollment, an individual may try out with a professional team at any time, provided the individual does not miss class. The individual may receive actual and necessary expenses for one tryout, limited to a 48-hour time frame. If the tryout is self-financed, it may last for any length of time, provided the individual does not miss class. We recommend reviewing the bylaw for further exceptions for men's basketball and men's ice hockey with regard to draft and scouting combines. Bylaw 12.3 outlines the provisions for the use of agents. The general rule states that an individual is ineligible if he or she or his or her relatives or friends agree to be represented by an agent or accepts benefits from anyone who represents the individual in the marketing of his or her athletics ability, or an agent, even if the agent has indicated no interest in representing the student athlete in the marketing of his or her athletics ability or reputation. There is an exception for baseball student athletes prior to full-time initial collegiate enrollment. An individual who is drafted by a professional baseball team may be represented by an agent or attorney during contract negotiations. However, the individual may not receive benefits other than representation from the agent or attorney, must pay the going rate for representation, and if the individual does not sign a contract with the professional team, The agreement for representation with the agent or attorney must be terminated prior to full-time collegiate enrollment. Bylaw 12.4 governs compensation to student-athletes for employment. In order for student-athletes to be compensated for employment, it must be for work actually performed, must be paid at the going rate in that locale for similar services, and pay cannot provide value to an employer based on the student-athlete's notoriety. Bylaw 12.4.2 outlines further provisions for specifically athletically related employment and activities, such as fee for lesson instruction, national team practice and competition, and athletics equipment sales. Name, image, and athletics reputation are important factors when considering such employment, and is equally important for self-employment. A student-athlete may establish his or her own business, but may not use his or her name, photo, appearance, or athletics reputation to promote the business. Bylaw 12.5 provides guidance for student-athlete participation in promotional activities and whether or not a student-athlete's name, image, or appearance can be used in conjunction with such activities. It is permissible to use a student-athlete's name, image, or appearance to support charitable or educational activities or activities considered to be incidental to participation in intercollegiate athletics. As Bylaw 12.5.1.1 suggests, this applies to member institutions, member conferences, a recognized institutional entity, a non-institutional charity, educational entity, or nonprofit agency. If an individual participated in non-athletically related promotional activities prior to enrollment, such as modeling, he or she may continue to do so if the individual became involved for reasons unrelated to his or her athletics ability. No reference is made to the individual's name or involvement in intercollegiate athletics. The individual does not endorse a commercial product in participating in the promotional activity, and any remuneration received is at the going rate for the individual's skills and experience, and is not based on athletic skill or ability. However, there are promotional activities student-athletes may not be involved in. Perhaps most notably, student-athletes cannot accept remuneration for the use of his or her name or picture to promote a commercial product or service, or receive remuneration to endorse a commercial product or service. If a student-athlete's name or picture is used to promote a commercial product without the student-athlete's knowledge or permission, the student-athlete is required to take steps to stop the promotion, which typically takes form by sending a cease and desist letter. Bylaw 12.8 governs season of competition and the 5-year rule. The 5-year rule outlines that a student-athlete may use up to 4 seasons of intercollegiate competition in any one sport within the legislated 5-year clock, which begins when a student-athlete initially enrolls full-time and attends classes. This bylaw also includes exceptions to the 5-year rule, criteria for determining seasons of competition, and delayed enrollment legislation. The delayed enrollment legislation varies slightly depending on the sport. For sports other than men's ice hockey, skiing, and tennis, students have a 1-year grace period from the date of their high school graduation, as determined by the NCAA Eligibility Center, until their first opportunity to enroll. For example, if a women's basketball prospective student-athlete graduates from high school in June 2018, her grace period would extend until June 2019. Her first opportunity to enroll would then be the fall of 2019. If she did not enroll in the fall of 2019 and then competes in organized competition, she may be subject to seasons of competition and must serve an academic year in residence upon enrolling before being able to compete. In tennis, there is a 6-month grace period as opposed to 1 year. Finally, in men's ice hockey and skiing, the grace period extends until an individual's 21st birthday. If you have further questions about the content in Bylaw 12, please feel free to submit those questions on RSRO. Thank you for listening to this presentation.